Welcome everyone to the Herbert Smith Freehills Disability Mooting Championship, Oxford and Cambridge. We're delighted to welcome you all today. My name is Dr. Marie Tidball. I'm the coordinator of the Oxford University Disability Law and Policy Project. We're about to launch the grand final this afternoon, but I'd just like to welcome our esteemed judges, biographies of whom are on our website, so do go and look at that. But I'm delighted to be joined by Professor Susan Bright, Professor of Land Law, University of Oxford, Dan Hudson, partner in corporate crime and investigations with expertise in business and human rights at Herbert Smith Freehills, and Professor Nicholas McBride, Fellow of Pembroke College and Director of Studies in Law at the University of Cambridge. I'm really grateful to them for joining us today and for what will no doubt be an exciting grand final. Just as an access note, as Gayatri already mentioned, if anybody would like to have a live transcription of this session generated through Otter AI, please click on the Otter AI link, which should now be in the chat. And also we have two British Sign Language interpreters for the session today. They will be with us the whole afternoon, and their names are Marie Oxham Hall and Claire Morgan. If you want to just watch the boxes that they will be appearing in on your screen, those are the names to look out for. Many thanks to them for the work that they will do this afternoon. And that just leaves me to pass over to today's clerk, Gayatri, to kick off proceedings.
Silence. The Supreme Court is now in session. Can we invite the lead counsel for the appellant to take the floor, please?
I am obliged. May it please the court, my name is Mr. Yin, and I begin the case for the appellant, Mr. Blofeld. My learned junior is Mr. Shah. My learned friends for Miss Bond are Mr. Emerson and Mr. Clement. Before I begin, my lordships and my ladyship, may I dispense with formal citations for the duration of my submissions? Yes. I'm obliged. Your lordships and your ladyship, would you benefit from a brief summary of the facts of this case, or should I begin with my submissions?
I press on with your submissions.
I don't see the need.
I am obliged, your lordship. My lords, my lady, the case today arises out of a set of difficult circumstances, but sadly not uncommon ones. We are faced with a question of balancing conflicting rights of the two parties. Today, I will make two submissions. Firstly, that there was not a sufficient causal link between Ms. Bond's eviction and her disability. And secondly, that even if such a link were to be established, Mr. Blofeld was entitled to evict Ms. Bond to exercise his fundamental rights over the property. My learned junior will then represent Mr. Blofeld on the cross appeal relating to private nuisance. With your leave, my lords and my lady, I will now turn to my first submission. My first submission is that whilst Ms. Bond undoubtedly suffers from a tragic disability, the sufficient causal link is not established. Per section 15, subsection 1A of the Equality Act, Mr. Blofeld's unfavourable treatment must be in consequence of Ms. Bond's disability for the exception in the Act to apply. To interpret the scope of this, may I draw your lords and my lady to page 23 of the bundle to the case of Risby, paragraph 18 of the judgment by Mr. Justice Mitting.
Sorry, could you repeat where you're taking us to?
Yes, my lady, to page 23 of the bundle to paragraph 18 of Risby.
Thank you.
My lords and my lady, it states here that if he had been disabled by paraplegia, if he had not been disabled by paraplegia, he would not have been angered by the respondent's decision. Contrast this with the present case. and it is submitted that it could not be said Ms. Bond would not be in debt if it were not for her disability. Since March 2020, Ms. Bond has unfortunately not been able to work in the cinema due to the COVID-19 pandemic, and thus fell into £2,400 of arrears by July, simply due to the fact that furlough was not able to cover her costs. Thus, your lords and my lady, turning to section 15(1)(a) of the Equality Act, although her situation may have been worsened later due to her disability, Mr. Blofeld can rightly claim that the arrears are not a consequence of Ms. Bond's disability, and thus I submit that it is not right to prevent a claim, it is not right to prevent Mr. Blofeld's claim in this case. Finally, in my first submission, my lords and my lady, we must turn to the reasoning for Mr. Blofeld's actions in his own mind. If I may draw you all to page 72 of the bundle, to paragraph 31b of PNESA. If my lords and my lady are prepared, Mrs. Justice Simler at this point states that the tribunal must determine what caused the impunged treatment or what was the reason for it, and the focus here is on the mind of A. In this case, I submit that Mr. Blofeld acted to exert his rights. In the Court of Appeal submissions, it is made clear that Mr. Blofeld relied on the income from renting out the flats, and this is why he wanted to be able to collect rent. As Ms. Bond was not paying this rent, it is submitted that rather than being a response to her disability, Mr. Blofeld was acting to protect his interest in having an income. Thus, my lords and my lady, it is submitted that there is no sufficient causal link between Ms. Bond's eviction and her disability. Before I move on to my second submission, do your lordships or your ladyship have any questions at this time?
Has Mr. Blofeld not waived his right to seek the eviction of Miss Bond by allowing her to continue in her tenancy after the point in time at which the first rent arrears occurred?
I am obliged, your lordship. My submission here is that it would not be beneficial from a point of view of policy to allow future Mr. Blofelds to believe that by waiting longer they would be punished and prevented from bringing a claim. I submit it is much better to encourage patience and support of tenants by allowing time to recover, although this time has thus passed. And thus I submit that it is more beneficial to allow Mr. Blofeld still to claim.
But allow sufficient time for the tenant to be detrimentally impacted by a disability?
Your lordship, I submit that as £2,400 of the arrears come entirely from the furlough rather than from the disability, it is submitted that there is sufficient costs that are owed that must allow a claim in this case by Mr. Blofeld.
But Mr. Blofeld didn't seek eviction on the basis of that at a point in time when he could have done so.
It is submitted, your lordship, that if Mr. Blofeld were to be found barred in this case, it would encourage future landlords not to wait and see whether their tenants could pay back the arrears at a future date, and would simply encourage them to immediately seek eviction as quickly as possible.
But he waited to see, and her situation deteriorated to the extent that she couldn't repay.
Your lordship, although unfortunately in this situation, the respondent has had their situation become worse, it is submitted that this was not foreseeable for Mr. Blofeld, and it would not be just to punish him for being more patient. Your lordship, I believe you're muted.
Thank you. I said, sorry.
I'm obliged, Your Lordship. I am aware I'm low on time, so I will move briefly to my second submission, if that is acceptable for Your Lordships and Your Ladyship. My second submission is that even if such a link were to be established, it was proportionate for Mr. Blofeld to evict Ms. Bond. Section 15, subsection 1b of the Equality Act permits an action that is proportionate. In this case, it is submitted it would not be disproportionate to evict Ms. Bond, as it strikes a fair balance between the disadvantage to the respondent and the claimant's need to assert his fundamental right over the property. If I may draw my lords and my lady to page 44 of the bundle, to the case of Ackerman, at paragraph 27. Here, Lady Hale states that there is no absolute obligation for landlords not to be entitled to evict a tenant, provided that it is proportionate. In this case, my lords and my lady, whilst my learned friends may submit that Ms. Bond has offered to pay back the rent, considering that she now struggles to breathe, she now has a new baby, and has not paid back the arrears to date, it is submitted that Mr. Blofeld could be forgiven for not having any faith that this rent will be returned. Thus, as he relies on the income from these flats, it is submitted that the only proportionate solution in this case to ensure justice is to allow Mr. Blofeld to evict Ms. Bond. Ultimately, my lords and my lady, the facts of this case are ultimately tragic. We regret that Ms. Bond cannot pay her rent, of course. Do we regret that furlough has not provided sufficient income? Absolutely. But in this case, we are not questioning whether we regret Ms. Bond's tragic situation. It is a question of legal right. And my lords and my lady, it is our submission that in this case, Mr. Blofeld's rights to exert his will over the property must prevail. Unless I can be of further assistance to my lords and my lady, that concludes my submissions at this time.
May I just ask a question on the latter point? My understanding is in the Court of Appeal, Lord Justice Mallory made this statement. Where possession proceedings are brought by a private landlord, the landlord's property rights will rarely, if ever, be of sufficient importance to justify limiting a tenant's right against disability discrimination. And I was wondering what your thoughts are on that statement.
My lords and my lady, may I have a slight extension of time to respond to this submission? I am obliged. Whilst we recognise that it is rare that there will be a situation where the landlord is able to have his right prevail over that of the tenant, it is submitted that this could not go to the extent where it is impossible in any case for the claimant, well, for in this case, the respondent to be evicted. In this case, my lady, the arrears piled up long before Ms. Bond was affected by the disability when she was unable to pay due to furlough. And in this case, my lords and my lady, the landlord is not a public landlord. He is a private landlord. It is not to say, in this case, unlike, for example, in Birmingham, it is not a case where Ms. Bond would be made fully homeless. She should be able to seek public housing if she is evicted or other tenancy. And thus, I submit that in this case, my lady, this is the correct case where Mr. Blofeld's rights should prevail.
Thank you.
May it please the court, my name is Oliver Clement, and I, with my learned junior Jake Emerson, will be advancing submissions on behalf of the respondent, Miss Bond. My lords, my submissions will take two parts. The first of these will be that the Court of Appeal did not err in its interpretation of the causal link required under the Equality Act 2010. The second will be that it is correct that the vindication of a property right alone cannot justify limiting a tenant's right against disability discrimination. My first submission, my lords, is that Mr. Blofeld did discriminate against Ms. Bond, as he treated her unfavourably on the basis of a consequence of her disability under Section 15(1)(a) of the Equality Act. Recent cases employ multiple causes analysis, and this should apply here where there is a loose causal link. Lord Justice Mallory was thus correct to apply this test, as per Risby and London Borough of Waltham Forest. My lords, at the point when notice was served by Mr. Blofeld, the arrears were a consequence of her disability. The Equality Act, or Section 15 of the Equality Act, does not state that the landlord must treat the tenant unfavourably due to a right arising as a consequence of her disability, but something arising. The something in this case must be the totality of the arrears which leads to Mr. Blofeld taking his decision. He decided not to evict her when the arrears were solely consequent on non-disability related causes. He made his decision to evict when the totality of the arrears was significantly contributed to by the disability related causes. This far exceeds the test set down in NASER and NHS England, that the cause need only be more than trivial. This is in terms of how the disability related arrears contribute to the overall state of the arrears, it's clearly more than trivial, it's significant. The exercise of his right, though it may have existed, was consequent on a decision taken due to Miss Bond's disability. It can therefore be said that Mr. Blofeld treated Miss Bond unfavourably as a consequence of her disability. Do my lords have any questions on this point? In that case, I'll go further to say that as Lord Justice Mallory made clear in the Court of Appeal, if we were to say that some of the arrears predating the disability-related cause, meant that there would be no discrimination, we would be subverting the broad protection of the Equality Act. The Equality Act intentionally provides broad protection for those people with disabilities. Disability often operates as to make the lives of those suffering with them not only more difficult, but also more complex. It is inevitable as a result that factual situations will arise frequently where people with disabilities are treated unfavourably due to a combination of factors, one of which is their disability, or indeed their disability may have contributed to many of them. But it is rare that there will be explicit cases where the disability directly leads to the discriminatory conduct. And indeed, this isn't the remit of the special protection of Section 15, disability discrimination. To say that it could only apply where the disability was the first cause or the only cause would severely limit the application of the protections of the Act. My lords, there is no authority that where disability is a cause, that it is one of many or a subsequent one, should prevent the requirements for Section 15(1)(a) of the Act being made out. Do your lordships have any questions on this point? If not, then I shall move to my second submission. My lords, Mr. Blofeld's eviction of Miss Bond is not a proportionate means of achieving a legitimate aim under Section 15(1)(b) of the Equality Act 2010, and there was therefore discrimination. If your lordships could turn your attention to Ackerman, Livingstone, and Ulster Communities, this is at tab 5, at the bottom of page 44 of the bundle, paragraph 28. Baroness Hale sets out how proportionality is to be assessed and gives reference to a fourfold test. The first, whether the objective is sufficiently important to justify limiting a fundamental right. The second, whether the measure employed is rationally connected. The third, whether the means chosen are no more than is necessary. And finally, whether the impact of the right's infringement is disproportionate to the likely benefit. Most of the cases in this area relate to social housing landlords, and thus the courts tend to assess these criteria by reference to the twin aims, as explained by Lord Newberger in Manchester City Council and Pinnock. This is referenced at Paragon, Azra Housing and Neville. Would your lordships like to be directed there, or are you happy with me saying the twin aims to you?
That's fine.
The first of these twin aims is the vindication of the landlord's property rights, and the second is enabling the authority to comply with other duties. Now, in Ackerman Livingston at 31, which is at tab 5, page 46, Baroness Hale notes, it certainly cannot be taken for granted the first of the twin aims will almost invariably trump that right, even where social housing is involved. As noted, social housing landlords are able to, it is more likely that they'll be able to act in a proportionate way because they have more duties which must be considered, such as the broader duty to provide housing fairly within the community. The court can only be concerned, in this case of a private landlord, with balancing the benefit between the two parties, there are no external duties to consider. The question...
May I just ask you a question about that, and maybe possibly what you're about to go on to? It seems to me that there is a material difference between social landlords and private landlords, which is obviously what you're discussing. But with a public landlord, the income that they get from their properties is spread across a very broad portfolio. So the impact of any individual tenant being in arrears is going to be very different on them than it is for a private landlord, such as Mr. Blowfield, who is wholly dependent upon this. And I was wondering how that plays into your discussion of proportionality.
Thank you, my lord. The way that this plays into my discussion is in the question that I would go on to ask. The balancing act we're doing here is very similar, but it is different. We have to ask whether the benefit to the commercial aims of Mr. Blofeld in his situation exceed the impact that it would have on Ms. Bond. And so in doing that, what we're asking is, what we're taking into consideration is, for example, the revenue he gets from other properties. And so your concern is embedded into the balancing act that the court must then go on to do, I believe. At 34 of Ackerman Livingston, which is at page 47, it is accepted that in a case such as this, the landlord would have to show there was no less drastic means of solving the problem. On the facts, Ms. Bond's financial circumstances have improved, and she is now not only in a position to pay off her rent as expected, but also her arrears over time. To evict Ms. Bond, where she is now in a position such that this is an extreme action, can never be said to be proportionate. A far less severe measure is available. Thus, in choosing to continue to pursue possession proceedings, Mr. Blowfield is choosing a more extreme route, and proportionality should not be made out. His commercial aims can be satisfied in a less extreme way. Limb 3 of the proportionality test, therefore, must fail. Even if we go on to limb 4 of the proportionality test, this will not be made out. At paragraph 28 of Ackerman Livingston, at page 45, it is said that there are some situations in which the ends, however meritorious, cannot justify the only means capable of achieving them. In this situation, even if eviction were the only means, the ends cannot justify this. Miss Bond is disabled, a new mother, would be overwhelmed by the pressure of moving, in light of her disability. To say the vindication of the landlord's property right should justify evicting a disabled woman on whom the impacts would be severe, and where that woman can pay both the rent and the debt, cannot be the position the court takes. The final limb of the proportionality test must fail. If it is said to be the case that proportionality can be made out, where there is a lesser measure available, and when the impacts are this severe, we would be unduly strengthening the ability of landlords to pursue claims which would lead to the eviction of disabled people due to temporary circumstances, and thus allow for disability discrimination by the back door.
Sorry, may I interrupt again? Apologies for doing this, but I'm keen to get to as good an understanding of this as I can. So Mr. Yin was mentioning that that Mr. Blowfield may rightly be, I can't remember the exact word he used, somewhat sceptical about the ability of Ms. Bond to pay, because we're talking about fairly substantial arrears. What would happen if if eviction is refused and then suddenly the arrears repayments aren't kept up with?
My lord, is my submission that this would speak to proportionality at the next assessment. For example, if it was found that her circumstances had recovered and then eviction was refused, then when this was brought back in another round of possession proceedings, the financial history of the tenant must be considered in the proportionality analysis. And at this point, she's in a position to pay. If it happens that her financial position is not stable, then that would be considered at the next hearing. Unless your lordships have any further questions, that concludes my submissions. Thank you very much.
Do we have a reply from one of the counsel for Mr. Blowfield?
Yes, your ladyship, that would be from me. My lords and my lady, my learned friend has raised some important arguments. However, we submit they are not sufficient to override those that we have made ourselves. My lords and my lady, as your ladyship in particular noted, Mr. Blofeld is entirely dependent for his income on the flats, one of which Ms. Bond is currently living in. Unlike with a public landlord who has a wide portfolio of properties, we see that Mr. Blofeld would significantly suffer in his income were he not to be able to earn from one of his flats, as he indeed has not been able to do properly for over a year. Thus, my lady and my lords, it is submitted that if this is not a case where landlords' rights will trump those of the equality outlined in the Equality Act, when will they? It is submitted this is the ideal case to demonstrate that landlords still do have a right to assert over their own property. Furthermore, as I submitted earlier, Mr. Blofeld cannot be expected to be confident that repayment is somehow guaranteed. Ms. Bond now has breathing troubles and is a new mother, as my learned friend pointed out. Thus, it is submitted that it will be even more difficult now for Ms. Bond to pay back the significant level of arrears, and thus it is submitted that it is not sufficient to say that Mr. Blofeld will get the money at some point in the future. Finally, in my final few seconds of my submissions, I submit that my learned friend has proposed too many proportionality tests. In Paragon Asra, Sir Colin Rymer stated at paragraph 51, and this is at page 117 of the bundle, if your lordships and your ladyship wish to look at it, that it would lead to vexatious and repeated applications if there were to be too many repeats of the proportionality test. And thus, your ladyship and my lords, I submit that now is the time to draw a line under this case to restore the proportionality found by the court at first instance and to find in favour of Mr. Blofeld. Unless I can be of any further assistance, I pass on to my learned friend and to opposing counsel.
Thanks, Mr. Ian. Mr. Emerson.
May it please the court, my name is Jake Emerson, and I'll be addressing submissions on behalf of Ms. Rose in furtherance of her cross-appeal addressing Mr. Blofeld's liability in the tort of nuisance. Both the trial judge and the Court of Appeal erred in applying the test for landlords to Mr. Blofeld and should instead have applied the test for licensors. They were thus incorrect in their conclusion that Mr. Blofeld is not liable in nuisance. I'll be making two main submissions. Firstly, Mr. Blofeld retained possession of the property, which is inconsistent with applying the test for landlords. Secondly, Mr. Blofeld had sufficient control over the property, which is also inconsistent with application of the test for landlords. He could have evicted these students at any time following breach of their license agreement, and his failure to do so makes him responsible. My lords and my lady, my first submission is that Mr. Blofeld is liable, as the test for landlords cannot be applied to him as he retained possession of these premises. There is a fundamental distinction in this area between the liability for landlords, which following Coventry and Lawrence No. 2 is very limited, and that for licensors, which following Cocky Leakert and Sedley and Deadfield and O'Callaghan, significantly more expensive. Why is this so? If I turn your lordships and your ladyship attention to the case of Cocky Leakert, this is at tab 11, specifically page 256 of the electronic bundle, paragraph 24. Here, Lord Justice First says, the landlord has limited liability because the tort looks to blame the person or persons who causes the nuisance. How do we judge who's to blame for causing the nuisance? We see this further in paragraph 24. The landlord has limited liability because he has neither control over nor possession of the property from which the nuisance emanates. Further in paragraph 25, we see that an occupier has been held to be in a different position. He'll normally be responsible for nuisance even if he did not directly cause it, because he is in control and possession of the property. We thus see that to apply the test for landlords, the owner must have neither control nor possession. How these words are to be interpreted is linked to why we require these. Firstly then, unlike a landlord, Mr. Blofeld retains possession of the property. The reason why possession is so key is that it determines whose land the nuisance emanates from, and thus who can be expected to take action to abate it. For a landlord, the practical answer is that it is not his land. The key feature of a lease is that while the lease stands, the landlord transfers nearly all proprietary interest to the tenant, only reserving limited numbers of rights for himself. When a landlord transfers nearly all proprietary interest to the tenant, it's not right to say that the nuisance really emanates from his land. And so it's right that he's only subject to limited liability. Mr. Blofeld, however, being a licensor, is in a fundamentally different position. He retains all proprietary interest in the property and merely grants the students contractual rights to reside there. Thus, if one asks the question, whose land really is the flat, there is only one answer. It is Mr. Blofeld's. And if the land is properly classed as Mr. Blofeld's, then the relationship lacks the key feature of a landlord-tenant relationship, namely transfer of effective ownership of the land for the period of the lease. And if the relationship is not akin to a tenancy, then the test for landlords cannot be applied. Unless your lordships have any questions on this point, I'll turn to my second submission.
Yeah, I'd like to ask you, what do you make of the statement in paragraph 29 of the Cocking case that it's possible to imagine cases where an arrangement is so much akin to a tenancy that the licensor could not properly be regarded as an occupier in the relevant sense? Do you agree with that and think it doesn't apply here, or do you disagree with that?
I disagree with that statement, my lord.
Mm-hmm.
This is mere obiter. Lord Justice Voss was not subjected to full argument on this point. What Lord Justice Voss should have recognised is that the key difference between a licence and a lease is who effectively owns the property, which is all about retention of proprietary interest in the property. Given that a licence cannot grant proprietary interest, Lord Justice Voss was wrong to speculate that a licence can be so much akin to a tenancy, the licensor can probably be regarded as an occupier.
So Mr. Blofeld has leased flat 3 to Miss Bond.
Yes.
But he hasn't leased flat 4. Why is that?
I imagine that Mr. Blofeld would like to retain flexibility. He likes to retain proprietary interest with himself. And it ought to be recognised that he gets benefit from calling it a licence and not a lease. If he gets benefit from calling it a licence, then he ought not to have his cake and eat it too. Being a licensor comes with responsibility because it's conceptually your land. If he wants to call it a licence and have it be conceptually his land, he ought not to shirk this responsibility by arguing that the test for landlords ought to apply to him.
Isn't it more that landlord makes it very difficult for him to have this arrangement with these multiple students, and students will be coming in and out while still calling it a lease? He would like to lease the land, it's just landlord doesn't allow him to do so. So isn't it unfair, because of landlord's deficiencies, to expand his liabilities under the law of tort? If this was a tenancy, there's no chance he'd be liable.
I disagree, my lord. One may speculate that the only reason that he's granting a license to these students is because the landlord won't let him. But these 3 students, they're leasing at the same time, they're renting at the same time. It would be possible to grant a tenancy. Mr. Blofeld retains other benefits out of the license, in that he's a flexibility to terminate it at times he wouldn't be able to terminate it if it were a lease. And given that he gets these countervailing benefits, which he happens to get from the landlord calling that a license and not a lease, it ought to be recognised that those countervailing benefits come with obligations and tort. However, if your lordships are not convinced on this point, turning to my second submission, not only did Mr. Blofeld have possession, but he has sufficient control over the property. The test for landlords cannot be applied to him. Given that the students are in breach of their license agreement, Mr. Blofeld could have removed them from the property at any point, thereby bringing this nuisance to an end. My lords and my lady, I'll be the first to concede that Mr. Blofeld has very limited physical control over these premises. The only rights of entry he has, namely inspection of condition, entrance to effect maintenance, are not particularly useful in preventing student parties. However, it would be wholly unrealistic to construe the word control as requiring physical control, especially when dealing with a nuisance caused by a person. Again, why do we require control? Well, control dictates whether the owner has the means necessary to abate a nuisance. One can easily see how in a case such as Sedley Denford and O'Callaghan, which involves a third party making a physical change to the land, physical control may be required. In such a case, the owner's control manifests itself in being able to enter the property and physically remove the nuisance. But if the case is not one of physical change, one of behaviour to a party, it's unclear how physical control can be required. Even if the owner does have a right of entry, what are they expected to do with it? They can't physically enter the property and remove the students with their bare hands, after all. And so, my lords and my lady, that's not what control means. That's referred to in the cases. Control means the means available to the owner to bring nuisance to an end. Mr. Blofeld has precisely such a means. The students are in breach of their license agreement, so he can stop the nuisances extremely swiftly by obtaining order for possession against them and removing them from the property. This is clearly a form of control, and it's recognised as such in the cases. If I may turn your lordships and your ladyship's attention back to Cock and Leacock, tab 11, at page 257, near the bottom of paragraph 26. When Lord Justice Voss considers the question of control, he does not refer to physical right to enter the property. Instead, he says this: Mrs. Waring reacted by terminating Ms. Eacroft's bare licence and obtaining an order for possession against her. She could then have abated the nuisance by enforcing that possession order, but chose not to do so. When deciding the key question of whether the licensor has sufficient control, the Court of Appeal thus placed focus solely on the means by which the licensor could remove the licensee, namely through enforcement of the possession order. There was no reference to an element of physical right of entry. Equally here, the court should focus on the means by which Mr. Blofeld can remove the licensors, and he has such readily available means.
Sorry, can I just interrupt you there? I'm struggling a little bit with the argument, which may be because I'm not sufficiently familiar with the law on nuisance and exactly what was said in Coventry and Lawrence. My understanding is that landlords are not going to be liable in nuisance for the acts of their tenants. Just correct me if I'm wrong along the way of the reasoning process, but that landlords still may have the element of control that you're currently discussing, which is the ability to terminate a lease and get rid of the tenants. And if that's the case, why is there such a clear ruling on landlords not being liable? I'm not sure if you're following my argument here, but if you're arguing control is the ability to end the arrangement and get rid of the occupiers, why the distinction between landlords and non-landlords?
I take your point, my lady. It was said in dicta in Coventry and Lawrence number 2 that a landlord merely failing to enforce a covenant which would evict the tenant is not sufficient to ground liability for them. But I return to the point that that is an element of control which is not recognised for landlords for reasons specific to landlords, which do not apply to licensors. That key conceptual difference between a transfer of almost full proprietary interest, meaning that the land essentially is the tenant's, means that if the landlord doesn't exercise the right to remove them, it's not his problem because it's not essentially his land. For a licensor having the right to end the license agreement, and that is sufficient control. And the fact that that's not recognised as sufficient control from landlords ought not to be a problem for your ladyship because of the conceptual differences between the two.
Okay.
In summary then, my lords and my lady, to apply the test for landlords to Mr. Blofeld would be inappropriate, as that requires neither possession nor control. And in my submission, Mr. Blofeld has both.
Thank you.
That concludes my submission.
Let's shall.
May I just interrupt briefly before we proceed, which is that in this virtual hearing, the lighting is going in my room and I just need to get up and switch a light on. So I'll be back in a sec. Thank you very much.
May it please the court. My name is Mr. Saifullah Shah, and I represent Mr. Blofeld on the cross appeal in this case. My lords, my lady, may I dispense with formal citations?
Yes.
I'm obliged. My lords, my lady, my underlying argument today is that Mr. Blofeld cannot be held liable for the acts of his licensees. He can be fairly regarded as the landlord of the property, and as such cannot be found liable under the rules laid out in Coventry and Lawrence. I make two joint submissions to support this. The first, that Mr. Blofeld's relationship with his licensees was for all intents and purposes like that between a landlord and his tenants. And the second, that under the test for liability in Coventry and Lawrence, Mr. Blofeld cannot be held liable for his licensee's nuisance as a result. I will now turn to my first submission. Submission number 1. The license in the present case was sufficiently similar to a tenancy to allow Mr. Blofeld to be assessed under the test for landlords rather than occupiers, as suggested in Cocking and Ecott and already raised by my learned friend. I would like to direct your lordships and your ladyship to page 258 of the bundle in the case of Cocking and Ecott, tab number 11, paragraph 29, to make a point already raised by my Lord McBride when my learned friend was giving his submissions. And in that, Lord Justice Foss said, I should not leave this topic without making it clear that the judge's decision was entirely based on the facts as he found them to be. It would perhaps be possible to imagine cases where an arrangement called the license was either held to be a tenancy or found to be so much akin to a tenancy that the licensor could not properly be regarded as an occupier in the relevant sense. Now, my learned friend made the suggestion that a statement by a Lord Justice in the Court of Appeal was not only mere obiter, but it was plain wrong. Now, I submit that this is a bold assertion plucked out of the ether. It was not challenged by any other of the justices in the case, nor has it been since. There is no good reason to believe it is a statement that does not apply, as it follows from the exact same reasoning Lord Justice Foss applied in arriving to his points that benefited my learned friend. To use my learned friend's own words, he cannot have his cake and eat it too. Now, the facts of this case mention that under the terms of this agreement, the licensee is entitled to reside in the flat in common with up to 2 other persons, and Mr. Blofeld is permitted to enter the flat only for the purposes of inspecting the condition of the flat and carrying out maintenance or repair work. This suggests a tenancy for all intents and purposes, and it would certainly be a stretch to describe Mr. Blofeld as an occupier in any meaningful sense of the word. He does not have possession, he does not have control, and as my lady already mentioned when intervening in my learned friend's submissions, any possession or control he does have is very much akin to the possession or control that landlords already exhibit over their tenants. Therefore, I submit that the case of Cocking and Ecott does not apply, and we should resort to the orthodox principles laid out in Coventry and Lawrence.
Mr. Shah, can Mr. Blofeld not simply go in and direct the noisy licensees to stop making the noise they're making, which has been causing anxiety to Ms. Bond?
He could, your lordship, and as I go on to in my second submission, that would not be sufficient for a landlord to be found liable under those facts. I will turn to it in time, but to briefly sum up, Lord Neuberger in the case of Coventry and Lawrence mentions that it is not enough for a landlord to be aware of a nuisance and take no steps to prevent it. And that is exactly what the case was on the facts of the appeal.
Mr. Shaw, may I ask a question? Again, nuisance is not my forte, but I'm interested in this relationship between possession and occupation. So you've been emphasising that it would be a stretch to describe Mr. Blofeld as an occupier here. But of course, as as was pointed out earlier, the the difference between a lease and a license hinges on this idea of possession. So possession isn't the same as occupation. I was wondering why you think that a legal consequence follows from saying that it's not right to describe him as an occupier, even though in law doesn't he still retain possession?
Yes, I'm obliged, Your Ladyship. I have emphasized the word occupier as that is the phrase used in the case of Sedley-Deinfeld, cited in the case of Coventry and Lawrence to explain the difference between the rules that apply to landlords and the rules that apply to those who do not meet the criteria of landlords. And in Sedley-Deinfeld, this is not in my submissions, but off the top of my head, it is mentioned that where landlord liability does not apply, the test for the occupier, and the occupier is liable for the acts of nuisance committed on his property due to, as I have said, possession and control. And I submit that the necessary possession and control in the context of Sedley-Deinfeld does not make Mr. Blofeld an occupier for the purposes of this appeal. If my lady is satisfied, and my lords, I will proceed to my second submission. That Mr. Blofeld cannot be held liable for the nuisance of his licensees, as he did not authorize it or participate directly in its commission. Now, if I could direct you, my lords and my lady, to tab 10, page 164 of the bundle on paragraph 11, in the case of Coventry and Lawrence. If your lordships and your ladyship are ready, Lord Neuberger, citing Lord Millet, states quite clearly, in order to be liable for authorizing a nuisance, the landlords must either participate directly in the commission of the nuisance, or they must be taken to have authorized it by letting the property. Now, Mr. Blofeld certainly didn't participate in the nuisance, as there is no evidence to suggest that he ever took part in the raucous parties of his student licensees. Thus, the only alternate possibility here is authorization. Now, this is as well in paragraph 11 on the same page of the bundle, your lordships and your ladyship. There is a high bar for potential liability, as it is not enough for them to be aware of the nuisance and take no steps to prevent it, as I have mentioned in response to one of your interventions previously. My lords, my lady, indifference is not nuisance. Apathy is not liability. And under the law, the fact that Mr. Blofeld knew of the nuisance caused by his licensees and took no steps to prevent it is immaterial to his liability. Moving on to the next part of my second submission, and this is on paragraph.
Just before you move on, Mr. Shard,
yes.
That of course is relevant only if we take the point that this is in fact a tenancy.
Yes, your lordship, so both my submissions are joint rather than alternate. Yeah. So I must have proved that the rules governing Coventry and Lawrence apply in order for this to apply as well. And your lordship, so for a landlord to authorize a nuisance, and this is on paragraph 12, for your lordships and ladies, on page 164 as well, there must be a virtual certainty or a very high degree of probability that a letting will result in nuisance. And Lord Neuberger explicitly rejects alternate, less stringent tests centered on likelihood or foreseeability. Now, a group of students moving next door to you in a house, is it likely that they will party? Perhaps. Is it probable that they will party? Perhaps. But it does not satisfy virtual certainty or a very high degree of probability. One would assume that the vast majority of students would engage in such loud, frequent parties, which is simply not the case. So although I can see that students partying regularly is quite likely, it is certainly not a virtual certainty as is required for implied authorization. Therefore, Mr. Blofeld did not authorize the nuisance and cannot be held liable as a result.
Do we have to take account of his knowledge though, Mr. Shah?
Apologies, I didn't quite catch that.
Do we have to take account of Mr. Blofeld's state of knowledge? He knew the parties were going on.
Yes, your lordship. So as I mentioned previously in paragraph 11, regardless of whether he was aware or not of the nuisance and took no steps to prevent it, is immaterial to his potential liability. And as for, I think I get your lordship's question, as for the virtual certainty, that I believe is an objective test for the court to decide. And I submit that objectively, it is not a virtual certainty. So aware that my time is up, I will briefly summarize. So in summary, my lords, my lady, Mr. Blofeld may have technically been the licensor of the property, but the legal relationship between him and his licensees was both markedly similar to that of a tenancy and far removed from occupation. The facts here are very different to the facts in Cocking and Ecott, which my learned friends erroneously submit applies in this case. Rather, he was for all intents and purposes the landlord of the property. The rules in Coventry and Lawrence apply, and as such, Mr. Blofeld is not liable for nuisance. And unless I can be of any further assistance, my lords, my lady, that concludes my submissions.
Thank you, Mr. Shah. Do you have any reply?
Yes, my lord. I'd like to just make a number of brief points. Firstly, on Mr. Shah's point that the partying and the nuisance was not a virtual certainty, I agree, but that rather puts the cart before the horse. The virtual certainty test is that which is applied to landlords, and I say that's not the right test. The right test is that applied to licensors, namely whether he failed to take appropriate action after being aware, which is precisely what he did. On the correct test to be applied, Mr. Shah said that somehow Mr. Blofeld may be an occupier, but not an occupier for the purposes of Sedley-Denfield. If we look at what it's required to be an occupier under Sedley-Denfield and Cocking and Ecott, it's control and possession. Mr. Blofeld retains full possession, as my ladyship noted in questioning, as he grants mere contractual interest. And finally, in relation to my learned friend's point on paragraph 29 of Cocking and Ecott, namely Lord Justice Voss envisaging that a license may be so similar to a lease as to be subject to the test for landlords. This is mere dicta, and I accept that it's not contradicted anywhere else, but this is the Supreme Court after all. And if we think it's wrong, we can say it's wrong. I did not merely pluck out of the ether that it's wrong. He gave a good substantive reason, namely that the landlord retains full proprietary interest. That is the licensor retains full proprietary interest. That is the key element. And if the licensor retains full interest and thus retains possession, it is never possible for a lease to be so akin to a tenancy as to have the test applied. That's my substantive reason. Unless your lordships have any further questions, that concludes my reply.
Thank you, Mr. Emerson.
Silence. The Supreme Court is now adjourned.
I've been tasked with giving the judgment on the law, in our opinion, and I would just say that I am looking to my colleagues to assist where I may not be as clear as I ought to be, or perhaps even misrepresent what we agreed, which I hope I don't do, but let's give it a go. But before I do that, I do just want to say what an excellent moot this has been. The quality of mooting was superb. So congratulations to all of those who participated in it. You did really, really well. Obviously, we're not commenting on who wins the moot itself at the moment. So this is limited to the our decision on the points of law that were appealed to the Supreme Court. So that said, the first ground of appeal which a permission was given for Mr. Blofeld was this: that the Court of Appeal had erred in interpreting the requirement for a causal link between the tenant's disability and the reason for repossession proceedings too widely. So this obviously relates to section 15(1)(a) of the Equality Act. And our decision in relation to this point is that there does indeed need to be a broad approach to causation that takes account of the policy underlying the Equality Act. And that in itself is therefore supporting the idea for a loose causal link as being sufficient. And And although we have a slight, we had a discussion about what exactly our remit is as a Supreme Court, and we wanted to decide on points of law and where we could also explain how we would apply them to the facts of this particular case. And on this point, we said there should be a broad approach to causation, and on these facts, we would also find that there was causation satisfied here. Any comments from my colleagues before I move on to the next point? No, good. Thank you. So the second ground on which permission to appeal was given was this. It says, secondly, as a matter of public policy, it could not be the case that where possession proceedings are brought by a private landlord, the landlord's property rights will rarely, if ever, be of sufficient importance to justify limiting a tenant's right against disability discrimination. This statement, we thought, was too narrow. We do think that there may be circumstances that don't really fit into the rarely, if ever, category, which may justify and may be of sufficient importance to justify limiting a tenant's right against disability discrimination. However, when we then try and apply that to the facts of this case, we didn't feel that we have sufficient information here, because that test wasn't the test that had been applied. And we would like to send this case back down, which I know may be disappointing to the mooters to hear this, but we do feel that we would, because we do think that that test was too narrowly expressed, we would want to send it back down to have a broader test applied on the facts to see whether or not the particular grant of eviction on these facts would be proportionate or not. Now, again, I'm going to pause then before I move on to the next point in case my colleagues wish to add anything on that point.
Only that there would be some overture in any supplementary judgment which might give succour to Ms. Bond on that point.
It must be said that the Supreme Court potentially had different approaches to the application of the proportionality test on these facts, which is partly why we decided we needed to send the case back down. Then if we move on to the third point of appeal, this was in relation obviously to the nuisance point, and it was the permission to cross appeal on the following ground. The Court of Appeal erred in holding that it was appropriate to apply, in the circumstances of this case, the rules governing the liability of landlords for nuisances committed by their tenants. I'm just trying to read my own writing here, so apologies for that. So the Supreme Court here, we were all agreed that it was not appropriate here to apply the rules governing the liability of landlords for nuisances committed by their tenants, because the occupiers here were licensees. And we did see that there could be a really a great risk of throwing the law into disarray and uncertainty if we start blurring the distinction between licenses and leases for these purposes. That said, the fact that we decided that it was not appropriate to apply the test for landlords on these facts means that, again, we're going to send the case down, because we would want to see if there were effective and reasonable steps that were open to Mr. Blofeld here, the licensor, in order to deal with the nuisance parties that were taking place, and whether he in fact took them. That, I think, unless my colleagues have anything to add, is the end of our decision here. Obviously, it's a rather brief one. I can see one of my colleagues doesn't want to add. The other colleague?
Only that I suspect that, in my view, Mr. Blofeld would struggle to win on that point when it goes back down. And without further ado, I will announce the results. But before I do, I just want to reiterate how high the quality of the mooting was yet again this year. The standard just keeps going up and up. We have some great advocates coming through from the university. So my thanks and praise and congratulations to everyone who took part, everyone who got through to the semi-finals today, everyone who took part yesterday in the preliminary rounds, and indeed everyone who entered the Moot but didn't get through. I hope everyone has success in the future mooting. So without further ado, I will say quite simply that the winners of the Herbert Smith Freehills Oxford Cambridge Disability Mooting Championship this year are Oliver Clement and Jake Emerson. Well done, chaps, and well done to John T and Soph Fuller, who were worthy runners-up.
Thank you so much, Dan. That just leaves me to close the event by saying huge thanks to everyone that's taken part in whatever capacity, both in organising and on camera, either as mooters, judges, or panelists, and to our fantastic organising committee, and a thanks as always to Herbert Smith Freehills for their support and belief in the work that we do here at Oxford. And it's been wonderful to be working with you again this year and to be part of such a fascinating event. And I hope those of you who are new to disability law feel like you've left this event with new skills, new insights, and that you, as you enter your legal profession going forward, whichever way that might be, that you use those skills in being really terrific advocates for disabled people. That's one of the big aims of this event, and also to make sure that we encourage more and more disabled people to come through and apply for law here at Oxford. And I also hope at Cambridge themselves become the lawyers of the future. So on that note, I'll say thank you to everyone. Do enjoy the rest of your evening, and let's look forward to next year. Bye.